Good morning. A controversial dispute about cancellation of settlement deed unilaterally. Normally, what happens? The father may have 3 children, 2 daughters, and when he stayed at one of the son's house, that son taking undue opportunity, uh, positive influence, may force the father to execute a settlement deed in favor of the one of the son. Thereafter, the other son, when he reaches the other son house, after having knowledge about the execution of the settlement deed, then he forces his father to cancel that settlement deed. These things are continuously happening, and so many things is yet to be settled. Then the question arises under Protection of Senior Citizen Act, Parents and Senior Citizen Act. There was a power to RDO to cancel the settlement deed executed in favor of the sons and daughters if they are not being maintained properly. So for that also there was a controversial judgment whether such cancellation is legally valid or not. But after going through the act, the courts time to time held that Maintenance of Welfare and Parents and Senior Citizen Act only empowers the RDO authorities if the deed contains any conditions or terms that subsequently not complied with. Then only there is a power. Otherwise, there is no power for cancellation of deed. Apart from that, whether you can maintain writ petitions against such registration of deeds by the registering authority. So all these full bench AR 2022 Madras 323, AR 2022 Madras 323, Sasikala was RDO, come Sub Collector Devakotai. There are multi-number of writ petitions were referred to full bench. Justice S.S. Sundar, G.R. Saminathan J. and R. Vijay Kumar J.J. The multi-number of writ petitions were referred. I think for all they have answered. Number 1, writ petition is maintainable. Challenging the registration of document, cancelling conveyance or acceptance of fraudulent transaction is maintainable. Okay, that is, then question arises whether this full bench judgment override the recently amended Registration Act, which empowers the registration authority to cancel the documents or deeds fraudulently executed, and there is an appeal provision therein. After exhausting appeal provision only you can go to High Court. Whether this full bench judgment override that statutory prescribed procedure or not, let us see that later on. Then the question of a unilateral cancellation of sale deed, registration of cancellation deed. Sub-registrar has no power to register document of unilateral cancellation. These all are the ratio. Then they say unilateral cancellation of gift or settlement deed. Unilateral revoked cancellable settlement deed is permissible only in respect of case falling under section 126 of the Transfer of Property Act. 126 recognizes the power of revocation where the donor reserves the right to suspend or revoke the gift on happening of any specified event. So that was also explained. Then reading with 126 Transfer of Property Act, which recognizes the donor to cancel the sale deed or gift deed, then they read that provision with Maintenance and Welfare, Parents and Senior Citizen Act, then held that only 126 provisions are applicable to that document, then only even RDO can cancel it. Then otherwise if you want to cancel the deed, instead of registering the cancellation deed before the registrar, you can only file civil suit. That was the final ratio. So these all are the ratio enlightened in AIR 2022 Madras 323 Sasikala case. So be careful about this. The history, what all are the historical events which facilitated the full bench to decide these issues, and what all are the writ appeals. So many things are there. So Supreme Court judgment was also followed here. AIR 2022 SC 8 followed. AIR 2016 SC 4995 distinguished. Descending with distinguishing, referring, following, all are different words being used while considering the binding nature of judicial precedent. I hope you understand. Best wishes. Be safe because this cyclone is likely to hit Chennai also and outskirts of Chennai. Best wishes.